me now proceed to the Democracy Act. Keep in mind, both the Democracy Amendment and the Democracy Act represent about 5,600 words. So it's a fairly quick read, and it really is a legislative approach that has taken us about 10 years to put together. So the words in here, there's not a word that got into this document by accident. It's been vetted over and over again, and culminating in a 2.5-day conference in Williamsburg, where we brought in constitutional scholars, political scientists, attorneys, political activists, and gone over it over that 2-day period where we commissioned papers, analyzed and discussed them. In fact, we have those days on video that at some point we hope to turn into a film that we hope would be very explanatory to the process when we have the resources to do this. But let me now go through the Democracy Act, and it parallels the legislative format that legislative bodies are familiar with. We have the Act as we describe it, and then we have Section 1, which is the title, which is called the Democracy Act. Then we have the Preamble, which is succinct, and just the first sentence: we, the people of the United States, inherently possess the sovereign authority and the power to govern ourselves. The rest just embellishes that very clearly. And then Section 3, we have the procedures that, of course, that are set up in the electoral trust that qualifies initiatives chronologically. That, incidentally, is a very important point. In legislative bodies, you have political parties that control the flow of legislation. When the people act as a legislative body, there are no legislative parties that divide up the legislature of the people. It's just a total constituency. And so how do you govern the flow of legislation? Well, the only way you can do it is chronologically. So you and I come in, we introduce legislation, it's given a number, and then the next group of people introduce legislation and qualify it, it's given a number, so then it flows chronologically. Now we have a provision where the electoral trust, if there's an emergency, like you got to declare war or something like that, you can do an initiative in 2 or 3 days if need be. So that, but in a normal course of events, you're able to deal with legislation in a chronological order, and like in Switzerland, you have a confusion, which I think is a confusion from my point of view. The people can put forth an initiative and the government can put forth an initiative, and they both are there at the same time, and it becomes very confusing because you vote for them at exactly the same time. Well, that's very confusing. That can happen under these procedures. One precedes the other. The people can vote on a piece of legislation, and then after it's passed, it's the law. The legislature, the Congress, can vote to change it, and of course it's changed. The people can change it again. The last law is the law. Just that simple. It's a chronology, and we all live by chronology, by time. So that's eminently put forth in the procedures, Section 3. There's another thing that's in Section 3 which is extremely important. The electoral trust shall take advantage of contemporary technology in implementing these procedures. We don't know. When I first started work on this, the Internet was not in existence, not at all in existence. And so now we know that the Internet can provide for the implementation of this very handsomely and very easily. And so rather than try and nail everything down, and this is what many times people who are unsophisticated in the legislative process, oh, every little thing has got to be nailed down. Well, all they do is make it so nothing functions. So you've got to really trust that people will come after us that are maybe a little more intelligent than we are, and that procedures and technology will come after us that are better than what we have at our disposal. And so this language right here in procedures, that the electoral trust will take advantage of contemporary technology in implementing these procedures. I know and you know that better technology will come forward that will be better than what we have at our disposal right now, and that we're telling them in the future, use this new technology. I know that later on we'll be able to have hearings where you'll be able to watch your television set, you'll be able to press a button and be able to give testimony at these hearings, where millions of people will be able to participate in this, in a voting process, just in the hearing process. Well, that's what we want to take advantage of in the future. So we just make this in a general statement in these procedures. Now, the next is under procedures, we got A, sponsors. Well, who should be a sponsor? You have to be a registered voter to be a sponsor. And you have to be identified as the person, and then of course the sponsors shall be identified on the initiative and in any petition, in any qualified poll. And I'll go into how that becomes, how we do that. And then the form of it, the form of the initiative. It has to have a title, it has to have a summary, it has to have a preamble. And then you have to have a reason for the initiative, and you have to explain why. And it has to have a complete text. This is boilerplate in any legislative body, but we have to have that kind of detail if we're going to have a proper initiative. And then the content of the initiative, it shall pertain to a matter of public policy. It can't be any harebrained idea that anybody has. It has to be relevant to the government of relevant jurisdiction. You know, if it's a federal matter, it has to be for federal. If it's for a local city, it has to be for a local city matter. You can't have federal stuff being put forth at the city level. These are basic, ordinary things that have to be thought of and put here in specific language. The title and summary shall be subject to the approval of the electoral trust. Now, most states right now, they're the ones that write the title and summary, and I found from actual experience that's how they sabotage the will of the people. And on 2 occasions I've had to go to court to get the bureaucrats to write exactly what the initiative is supposed to say, because they were twisting it to make sure that they sabotage the initiative. So we let the sponsors write what the subject is, and we let the electoral trust read it and look at it and make sure that they're not playing games with the title and the summary. Now the next is a subject. It should only be one subject. In the Congress, when I served, we used to have Christmas tree bills, and that is, you put up a piece of legislation and everybody puts up every kind of subject. Here, you got an appropriations bill for military appropriations. Well, they'll put on a bill for school prayer. They'll put on an amendment for abortion. They'll put on an amendment for God knows what, and that's called a Christmas tree bill, because they know this legislation is going to pass, and they try to load it up. Well, that's not a proper way to legislate, but they do it in every legislative body. But you are not going to do that kind of silliness when the people are legislating, so it's going to have only one subject. And now, a word limit. It's going to have a limit of 5,000 words. If you can't explain one subject in 5,000 words, I got to tell you, there's game playing going on. And of course, you have initiatives in the 24 states where they've had so many words that nobody reads it. And that, of course, is a kind of a way to obfuscate and fool the people with phony initiatives, and they do this in Congress with legislation. Here, bills. The Patriot Act was over 300 100 pages, and it was put on the desk of members of Congress the day before they voted on it. Do you mean to tell me that the Congress read the Patriot Act before they voted on it? Of course not. And I'll tell you, 95% of what the members vote on in Congress, they have not read. 95% of the Congress vote on legislation they have not read. Part of it is because they don't have the time, and part of it is because it's a committee system. And I'll go into that as we proceed into this. Now, the next section we have are qualifications. And that, of course, is now, this is very key because people have to ask, well, how do you qualify an initiative to be presented to the people? Now, in a legislative body, like in my case when I was in the Senate, the fact that I got elected to the Senate qualified me to introduce legislation. Now, the fact that I introduced it, that qualifies me to put forth a bill. Doesn't mean the bill will be passed. It has to go to committee and be voted on by the body, the Senate, and then the House, and then both together. But what qualifies an initiative put forth by a group of people to then be voted by all the American people or by all the people in the state? Well, there's three ways of doing it. There normally is two ways in most of the states. One way is by petition. People go out and get enough signatures to be able to determine, are there enough people that think that this is a serious enough subject that it should be presented to the balance of the people in a relevant constituency. And the states, here again, it's representative government, that set up a percentage of signatures that you should get. And then they play games. Oh, that the people who collect the signatures have to be citizens, or you can only pay them so much, or you can't use other signature gatherers from other states. It's very, very convoluted, and it's a silly game that's played to make it difficult for people to qualify initiatives. In California, it takes about $1 million to get an initiative qualified for the ballot. Now, that's not for ordinary citizens to really assert their rights. There's another way to do it, and that is, of course, a way that I added to this process. And now, with this process, you can now use electronic signatures, which means that you can now do this very cheaply rather than the way you do it in the 24 states. You could do it very, very cheaply. You could do it through the internet. So now you could set up a percentage, and we leave the percentages open because at the federal level and at the state level and the local level, you'll have different percentages because you're dealing with different population sizes. And so if it's a large city like New York, Los Angeles, Chicago, that's one percentage. If you're dealing with a small community of 8,000, like Wasilla, Alaska, 6,000 people, you can have a different percentage. So let's leave that up to the judgment of the electoral trust. And that's, of course, why you elect these people, to have it fairly determined by people who have judgment and want to make sure that it is fair for that. So that's a policy question, and that's why you have these elected people. So they will make a judgment of what percentage, but it'll still be very easy because you'll be able to do this on the internet with electronic signatures. But another way to do it, which is one of the ways I like it, particularly federally, and that is you'll be able to take a federal poll. You can take a federal poll for about $25,000, $30,000. And so if 50% of the people, and here too that's a determination made by the electoral trust, if 50% of the American people in a poll feel that this should be voted upon, then it's qualified. And that's a fair process. And then, of course, the last is the legislative resolution. If the legislative body of relevant jurisdiction, the Congress, the state legislature, or the city council, vote by resolution that the initiative in question should be put before the electorate without changing a word, then it's qualified. So those three ways are how a legislative, how an initiative is qualified. That's it. So now, The cost of qualifying is paid for by those who are the sponsors of an initiative. From that point forward, you need not spend a penny more in support of your initiative. The rest of the process is covered by the public monies of the initiative process. That is very significant to the democratic process in question. Now, let me repeat, this is very, very important. The people who sponsor an initiative can contact the Electoral Trust and receive assistance in the drafting of an initiative. Then they go out and get it qualified by any one of these three methods: by citizen petition, by a public poll, and by legislative resolution. And they pay for this process. But after they get it qualified, the sponsors do not have to pay for any more of the initiative process. That is all paid for by the legislative trust, which is funded. Its activities are funded by the public, by taxpayer dollars, because that is the initiative process. Just like the Congress. The legislative process of the Congress is paid for by taxpayer dollars. The legislative process of the state government, the legislature of the states, is paid for by taxpayer dollars. The legislative process of the city council is paid for by the taxpayer dollars of cities and counties. This is no different than that legislative process. The legislature of the people is the same way as those processes. That was F, qualification. Going on to G, withdrawal. The sponsors of an initiative may withdraw their initiative from further consideration and processing at any time prior to a deadline established by the Electoral Trust. And that's up to the Electoral Trust, because once an initiative moves through the pipeline, at a certain point, the sponsors may not be able to withdraw it. And that's up to the Electoral Trust to make that decision. H now goes to public hearing. This is very important. In the existing 24 states in the United States, the shortcoming of all of these states, they do not have a legislative process. The initiatives are qualified by people throwing a lot of money at them, getting signatures, and then people vote on them. Well, that is not a legislative process, and it's very poor legislative process. All legislative bodies basically have procedures, hearings, markups, and all of that. We do the same thing. So the legislative process is what we follow with this national initiative. So one of the first things you have is a hearing. So the Electoral Trust has a body of professionals, attorneys, political scientists, specialists in the various fields, and so they have a hearing officer, much like the implementation of workmen's compensation laws, where they have hearing officers to go out and conduct hearings. So the Electoral Trust, for an initiative, will appoint a hearing officer, and we, the sponsors of an initiative, will then, with the hearing officer, conduct a hearing, and the hearing officer will invite the relevant representatives from the legislative bodies, the relevant legislative bodies. It'd be the committees from the Congress in question, or the members of the City Council in question, or the state legislature, and they would participate in a hearing. And that hearing would bring forth experts, general citizens, and proponents, opponents of the initiative. And here too, they would be using the most advanced technology to do this, and they would, maybe the hearings would be done nationwide or area-wide. You name it, it's up to to get the broadest representation as possible, the greatest degree of input into this initiative. And they would develop a hearing record. When the hearing is complete, then we would move to a deliberative committee. Now, in a normal legislative body, you assign the legislation to a subcommittee, and it's the committee and the committee to a subcommittee, and the committee is the one that holds the hearings. Well, now you have a hearing that's held by the Electoral Trust, and then we have a deliberative committee. This was an idea that was picked up by a professor that was done in Germany, and so a deliberative committee, and it's somewhat similar to our jury system, where we would develop, the Electoral Trust would develop a pool of probably 10 million Americans who would be qualified. And you don't have to have 10 million Americans that have to have PhDs, but it would be a total spectrum of the American population, some educated, ordinary citizens. And from that pool, that people would be picked that would be for each initiative, and they would then be paid what they normally earn, not like the jury process now where they're paid unfairly for the time that they serve. And of course people don't want to serve on juries, but if they were paid fairly, they would be inclined to serve properly, and we'd get not people that are idle and housewives. We would get a really cross-section of our society. And so they would be prepared to serve on these deliberative committees, and these deliberative committees would receive the hearing record. They would have the ability to call in experts. They would then, we, the sponsors of an initiative, could sit with the deliberative committee and deliberate with them on our initiative. They could call in opponents, and they, by a 2/3 vote, could change, could amend our initiative. So it would be really operate just like a legislative committee in a legislative body, and thereby improve the initiative and bring it forward for action. Then they would vote, and if they amend it, then it would have to be a 2/3 vote to bring it forward. Now, after they have a vote, it then goes to, next is J in the process, which is the legislative advisory vote. At that point in time, it now goes into the pipeline for when it is going to be put before the people for a scheduled vote. But at the same time, it is sent to the legislature of relevant jurisdiction. If it's a federal, it goes to the Congress, and the Congress has 90 days to vote on the legislation in an advisory capacity, an up and down public vote, yeas and nays. Same thing for a state legislature, same thing for a city council or a county. They have to vote on it in a public. So this is an advisory vote, so that it helps the people, when they eventually will vote on it, to be able to say, well, I voted for Charlie there, and I trust him, and he voted this way, and I may not have the time to pay attention to this legislature, to this initiative, but I trust him, and so I'm going to vote for it, or I may not vote for it at all. Or I don't trust this guy, and he voted for it, so I may vote against it. So legislative bodies vote on cues. In fact, we live our whole lives on cues. We trust that somebody has vetted the milk we drink or the meat we eat. And so it's the same thing with legislation. So we trust, and so sometimes we want to be informed, but we don't have the time, so we'll trust other people, and that's the process. And this will be a very interesting dynamic, because we'll see representatives in government that may truly vote their intellect rather than vote the politics of what's going on in an advisory capacity. So this is a very interesting dynamic. This, incidentally, is the only thing that we do in the national initiative to representative government. We do not alter any other facet of representative government other than require that representative government vote in an advisory capacity to the people to the legislature of the people, helping them and make a decision on what they should vote, yes or no, whether they should vote yes or no. The next is K, the election process. The electoral trust will publish the schedule of when the election will take place and the conduct of the election. What they can do is they can hold very interesting elections. My suggestion, and we'll let them choose. You don't want to nail this down, but here's what's possible. They can decide that they can have an election over a 7-day period, 24 hours a day over 7 days, and that the people can vote by internet, on your computer, by telephone, by snail mail, going to the library, by kiosk. They can make voting so easy rather than the silliness of having to go out on a rainy Tuesday once a year. It's just so ridiculous. Trust me, my experience has taught me, with being involved in politics since I was 15 years old, that representative government designs to make it difficult for people to participate in representative government. They don't make it easy, and there's a reason for that, because they don't want you to participate. They want to exercise power that they hold, and they don't want you to participate. Trust me on that one. So that's the election process. It will be made so convenient to the process. And here too, if they decide that they will be at the federal level, one federal election, and we can look at the way it's operated in Switzerland, they probably have 4 federal issues a year. Trust me, by the time the people get used to this process, it'll be difficult to get 4 federal decisions out of the people a year. Make a list of all of the federal issues that you think that the people should vote on. You'll have a tough time getting above 20. And so after a year or so, you'll have a tough time getting to 52 issues a year, which means that that would be one federal issue a week, and that would be probably the first year. Once you get over it and the people get used to this, you won't be seeing the people putting forth the same old issues. People will decide these issues pretty definitively. But you'll have the opportunity, if it's one issue per jurisdiction a week, that means that you could have one federal issue, one state issue, and one local issue, so you could, at max, you could have 4 issues a week that you'd be voting on. And that's the max that I would foresee based upon my observations of what issues have been percolating to the top of initiative states and in initiatives around the world, places in Germany that have experiences just like in the United States at the state level, and in Switzerland. L, the enactment. This is a repeat of what was in the amendment, the Constitution, the Democracy Amendment. Several of the points are repetitions, but it's important that it be in the amendment. And let me make one point here. Most of the details of the statute should not be in the Constitution. It clutters up the Constitution, but certain elements must be in the Constitution because they're that fundamental. And the enactment is fundamental, and that's why it appears both in the Constitutional Amendment and in the Act. And let me repeat it again, and that is, when you're amending the Constitution in the enactment, which is section L, and that is that it takes 2 elections, 2 votes to amend the Constitution. 2 majority votes, 6 months apart, no longer than a year apart. And if you pass it in the first, if you fail in the first one, the amendment's dead. If you pass it in the first vote, then you have to have another vote, 6 months, or at least no longer than a year. And if that passes, then the amendment is passed. If it doesn't pass to the second one, the amendment fails. However, when you're enacting a statute, you need just a simple majority of the voter turnout. The other needed a majority of the registered voters. You begin to see the difference. So if you're talking about a constituency of, let's say, 100,000 voters, all you need for an amendment to the Constitution is you need more than 50,000 voters to pass the amendment. However, if you're enacting a statute, you could get the majority of 30,000 that turn out and you could pass a statute. It's a very critical difference because it's very important to have it very difficult to amend a constitution since it's such fundamental law. The next is M, the effective date. All laws have to have an effective date. And so if it's not in the law itself, we provide that the effective date is 45 days after the initiative is enacted into law. The judicial review. This is very critical and must be understood. Laws enacted by the people, just like laws enacted by the Congress or any other body, are subject to judicial review. Now, laws that are in the process of being enacted are not subject to judicial review except if there's a fraud being committed. Now, that's not the case with right now with the 24 states that have initiative laws. And that's exactly how representative government does sabotage a lot of initiatives put forth by the people. They really sabotage them through the judiciary invading the legislative process of the people. Well, they can't do that when the legislature acts, but they do that when the people enact laws. Well, they can't do that under this process. When the people enact laws, they're entitled to enact the law, and if it's unconstitutional, well, the courts can declare them unconstitutional. But you can't do that in the process of the people enacting the law, which they do now with state laws. The courts have no power to invade a constitutional amendment because it's a constitutional amendment. Now, here too, they cannot, there's nothing to adjudicate. If there's an amendment, they can interpret what the amendment says, but they cannot declare it they cannot void a constitutional amendment. They can determine what it says. I hope that's clear. The O is promotional communications. Anybody who is trying to promote information about an initiative or against an initiative must be identified, and the communication and the procedures to identify the person in question will be determined by the electoral trust. This is very, very important. And as you know, like in a presidential election, people watch, an ad is put up and Obama or McCain, this is approved, and I approve this ad. Well, that's a way of identifying the communication. Well, the electoral trust will define how that identification is done. And it's done one way for newspapers, it's done one way for television, it's done one way for radio. And here again, when you get into sophisticated technology, there will be different ways that it will need to be done. And that's where the electoral trust needs to have a little bit of slack to be able to determine how this is to be done. But we need to have identification of all of these communications, so the people will know who's opposing and who is for these and the nature of these communications. P is campaign financing. This is extremely important. Who's putting up the money for and against these initiatives? And so, as I pointed out earlier, in the constitutional amendment, money can only come from a natural person, cannot come from any kind of organized group, which generally is organized as a limited liability corporation. So they have limited liability, otherwise they could be sued. So it only can come from a human being. Now, keep in mind that if there is, this is not followed, keep in mind what I have here in the law. Violation of these prohibitions is a felony punishable by not more than 1 year in prison, or a fine not to exceed $1,000, or both per instance applied to each person found guilty of the violation. This is serious, and it's made serious intentionally. All you got to do is put one of these people in jail who violate this, and you'll see that you'll clean up this process big time. Q, financial disclosure. Obviously, there'll be extensive reporting of, with respect to people who support and oppose initiatives. And the same penalties will exist, that is, a year in jail, $100,000 fine for each individual who commits the felony in question. And now, keep in mind, this sum of money and this amount of time in jail may be relevant right now. It may not be relevant 10 years from now or 50 years from now. Any one of these things can be amended by the people, and it may make the Electoral Trust, it can't change this, but the Electoral Trust may make recommendations to the people to make changes based upon their experience. But this is the law. The Electoral Trust can't change the law, but they can, based upon their experiences, make recommendations to the people to enact changes to this particular law that would be enacted by the people. Next we come to Section 4. Now we've just gone through the first 3 sections of the Democracy Act. Section 4